Hey guys, welcome back to today's video because we've got a sovereign citizen courtroom moment that I almost forgot I had waiting in the lineup. And trust me, it was worth the wait. I needed this case to fully wrap up before finishing it. And the ending turned out even better than I expected. Not because the sovereign citizen did anything impressive, but because the judge's reactions to his ridiculous answers and discovery questions are absolutely priceless. I told you this one was going to be good. So let's get right into it.
You're on the record calling 2-1-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. No appearance.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, P44018, on behalf of the plaintiff.
And your name, sir?
Kevin Hurst.
Okay, where are we on this file, people?
Your Honor, we had a pretrial. You opened up a written discovery. We did send discovery out. We did receive it back, apparently unopened, indicating there was a written, on the envelope itself, it had written, I'm reading here, I do not accept your offer to contract, all rights reserved, UCC 1-308, signed, and then it was a return to sender, Judge.
All right,
So we attempted to do discovery anyways.
Mr. Hurst, did you refuse to accept the mail?
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to accept any mail that comes to me.
And what the hell does freeze even mean? Are you having some kind of seizure or something? Because you'd have to be completely out of your mind to think that scribbling "I don't accept" on the outside of your discovery packet with an edible highlighter is going to magically get you out of the legal donkey mess you drag yourself into.
This is what we're going to do. One of the things she sent you were requests for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
Objection, Your Honor.
Do you understand what I have said?
No, I don't.
All right, here it is. By open written discovery in this matter, you have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admissions. Those requests for admissions are in writing and they must be answered under oath and in a certain time frame. If they are not answered and filed in accord with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you.
Your Honor.
You don't want to accept it.
I'm not even sure. I do not have any understanding of this is my debt or not.
And what did you think was inside that packet? You refused to accept? Honestly, rejecting your discovery packet was probably the dumbest move you could have made, because now you're basically walking into trial completely blind, not even knowing the full allegations against you or exactly what evidence the prosecution has lined up to bury you.
Just coming with these allegations. I'm trying to see and verify if it is. Then when they called me the first time, they should have sent out verified documents stating that the original creditor and who it was and that I truly owe this debt.
Well, Your Honor, I just indicate that we did attach to those.
They already,
Excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. I wasn't finished. She
right,
cut
I'm going
me
to
off.
mute you, Mr. Hurst. I'm not going to have this.
Your Honor, she cut
I'm
me
not
off.
going to have this.
Talking.
This is not a clown show.
Oh my
One
goodness.
at a time.
I can't finish my
You
statement.
will speak one. Don't interrupt me again, Mr. Hurst.
Go ahead, sir.
Why, thank you. You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr.
Yes,
Hurst.
I don't understand anything.
Okay, fine.
I don't even understand why I'm here.
I'm going to mute
I don't
you.
even understand what's going on.
Oh, that I don't doubt for a second, honestly. I'm not even convinced you can tie your own shoes without somehow managing to eat one of your socks in the process.
I'm muting Mr. Hurst, and I will let Ms. Strickhardt say what it is she wishes to say. then I will unmute Mr. Hurst and allow Mr. Hurst to speak. Ms. Strickhardt, you were responding, Mr. Hurst.
Yes, sure. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in, all of those materials were in the packet that was rejected, Judge.
Well, let's let Mr. Hurst respond.
Okay, so the understanding that I have is that they should have contacted me 5 days after they should have gave me documents 5 days after they contacted me about the alleged debt. I told them I have no recollection of the debt. Yeah, I don't even know enough information to admit or deny the allegations to the debt. So if they're accusing me of this debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me. And that's why I refuse the packet, because I don't know if they're trying to contract with me or not.
Trust me when I say this. Sovereign citizens are financial black holes, and nobody with a shred of common sense or a working bank account would ever be stupid enough to sign a contract with you.
I didn't know what it was, so I sent it back.
All right, let me explain it to you again. Whatever political views you have,
I had no understanding that they were sending me these things. They didn't even tell me that they was going to send me. In the last court date, did they say, or did she say, we're going to send you something?
Sir, I opened written discovery. That allows you to serve written discovery. That allows her to serve written discovery. And she did so. If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. But I would urge you, and let me tell you, as I told you at the beginning, you have an absolute constitutional right to represent yourself, but what you do not have is a right to your own set of court rules. You may not be frustrating the court rules, sir, by refusing to accept mail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences of that. I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences of the choices that you are making. However, as I indicated, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. So I'm going to give you another date. And sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules will cut against you, then so be it.
Sounds like a fair deal to me. If you want to completely ruin your own life, go right ahead, because nobody's going to stop you from making a total fool of yourself. And definitely not Judge Robinson, who's going to end up having a genuine laugh at your expense by the end of this video.
I got a question. They are claiming that this debt belonged to me. Would they have to produce all the proof and verify that this debt belongs to me?
The plaintiff has the burden of proof, Mr. Hurst.
That's right. So she had to produce the proof that this debt belongs to me, right?
She has the burden of proof.
Okay. Thank you.
All right.
Judge,
I'm sorry, Ms. Strickhardt?
Your Honor, would it be possible for us to receive a motion date for, say, mid-July?
Let's give him one more opportunity.
Oh, you want me to resend the packet, Judge?
I want you to resend the package. And sir, let me urge you as strongly as I can. So receive and open the package. Because if you do not, the request for admissions will be deemed to be conclusively admitted. The lawsuit, as a practical matter, will be over. Do you understand what I have said to you?
Yeah, I understand. I got a question. Should they have sent me something before they sent me this package since the last court date?
Sir,
to verify that?
Sir, they're not required. If you think you need some information, you have the right to seek discovery too. But you can't tell them how to litigate their case.
Okay, so she's going to send me a packet, and I'm going to send her back a packet as well, right?
No, you're going to do what you choose to do. She's going to send you again those requests for admissions.
Well, you said the
Don't interrupt me again. We had this conversation before, didn't we?
Sorry.
We had this conversation before.
Go ahead.
As a courtesy to you, she's going to send you the request for admissions one more time. You will either accept the package or you will not. You will answer and serve the request for admissions in accord with the Michigan court rules, or you will not. And then if you do not, then those things will be deemed to be conclusively admitted. If you choose to send written request for discovery, you have a right to do that too. You can send written interrogatories, request for production of documents.
Well, yeah, same situation as her, but not really the same, because he doesn't have 8+ years of law, school to help him defend his own case. So that wraps up the first appearance. He finally accepted the packet. And now, let's move on to the second appearance.
We are on the record. This is 21-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearance.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, P44018, on behalf of the plaintiff.
And what is your name, sir?
Kevin Hurst.
Okay. All right.
I do hereby reserve all of my rights, claiming none, not to be compelled to perform under any contract or commercial agreement that I did not enter knowingly, voluntarily, or intentionally. I do not accept the liability of any compelled benefit or unrevealed contract or commercial agreement without prejudice.
Yeah, he's about to serve up a full plate of pure stupidity with a side of dumb nonsense on the house. Now we're finally getting to the part I've been teasing this whole video. And when I say fun, I mean fun for the judge, because this is where it really starts getting embarrassing.
Is there anything else you want to say, Mr. Hurst?
That's it.
All right. All right, where are we on this file?
Judge, discovery's been completed. Motion for summary has been filed. We are looking for the court to assign a date.
Okay. Let's get you guys a date. Mr. Hurst, do you have the motion for summary disposition filed on behalf of the plaintiff?
It looks like this.
What's that?
It looks like this.
I'm asking
Yeah.
the person who received the motion for summary disposition filed by the plaintiff.
Do I have it?
Yes, sir.
Yes.
Okay. So let's set you a date for hearing and we'll move on. Does July 26th at 10 o'clock, does that work for everybody?
Yep.
Yes, Your Honor.
Okay. July 26th at 10 o'clock, we will hear the plaintiff's motion for summary disposition. Sir, if you wish to file and serve an answer to that motion for summary disposition, you must do so within the terms provided in the Michigan court rules. You'll hear the motion July 26th at 10 o'clock. Again, sir, if you want to file an answer, be sure to serve both the court and the counsel for the other side. The court has had an opportunity to review the pleadings here. I was particularly interested in the request for admissions that was served by the defendant. Request for admission number 3. Does the plaintiff admit and have proof that the allegations against the respondent are true and accurate, with all documentation being verified, signature and seals? These were admitted. Does number 4, does plaintiff admit and or have proof that the statute of limitations has not expired to collect on his alleged debt? Plaintiff admitted that. Does the plaintiff admit number 6 and have proof that the respondent had a meeting of the minds with Credit One Bank pursuant to the contract agreement in respect to full disclosure, and that said contract contains no elements of fraud by Credit One Bank? Plaintiff admits that. In number 7, does the plaintiff admit and have proof that Midland Credit Management purchased this contract from the original creditor and is now the new owner of the alleged contract and of the said debt that is owed? Plaintiff admitted that. So what we have is we have an admissions by our defendant of the validity of the contract, admission by a defendant that Midland creditor is a proper party plaintiff. And then we have in request for admission number 8, does plaintiff admit and have proof that Credit One Bank did loan their credit to respondent and that the respondent is only obligated to pay back in money to Midland Credit Management? Plaintiff admitted that too. I Also note for the record that having reviewed the brief answer to plaintiff's motion for summary disposition, first of all, contrary to the courtroom, is not supported by an affidavit. 2.116G4 says that when a motion for summary disposition under C10 has been filed and served, the opposing party here would be the defendant, may not rely upon his pleadings, but must, by affidavit or as otherwise provided in this rule, demonstrate the existence of general issue of material fact. Again, I note for the record, no affidavit was submitted here. I think it's fair to say that the pleading filed by the defendant is somewhat obtuse. I quote, for example, from the third page, the agreed upon proof of claim was not served in place of the original account, for it is a conditional acceptance and not the foundation of an action, and does not become an original demand and amount to an express promise to pay the actual sum stated. In his first paragraph, the plaintiff, and I'm quoting again, plaintiff claims that the living soul utilizes an address in his answer, when in fact the address that is used there indicates that the living soul does not live at this address, but is receiving mail there. So the defendant has failed to approve. He's failed to support his brief answer to plaintiff's motion for summary disposition by affidavit as required by the court. The court has had an opportunity to review the pleadings filed on behalf of the plaintiff in this matter, and I'm satisfied. There's no general issue of material fact in this matter. Summary disposition is granted in favor of the plaintiff. If you'd be kind enough to send me your judgment under the 7-day rule item.
From here, the pressure turns up. The judge locks onto the contradiction and keeps the questions tight, forcing the defendant to either admit the truth or keep spiraling. You can hear the room shift. This is where the case stops being explained and starts getting exposed.
All right, and that brings us to Mr. Johnson.
Hello, how you doing?
I'm doing fine, thank you. We are on the record in 2024 TR 541, State of Kansas versus Danny Lewis Johnson. County Attorney Jill Gillette for the state. Mr. Johnson appearing in person and in custody and pro se. Now, Mr. Johnson, I just saw you, I believe, last week, and I order that you be held for a limited time for contempt of court. And then I understand the military put a hold on you. They were having some problems with you cooperating with picture and prints. Are we past that? Did you get your picture and prints taken?
I did not, ma'am.
Why did you not do that?
Because I didn't feel like it was, I was here for a criminal offense and there was no jurisdiction for me to get fingerprints and photos, ma'am.
All right, well, you understand that you need to do that. You're probably not going to get released until you do that.
Okay.
But in any event, you're also here today on a new case, and this is 2024 TR 541. You're charged in count 1 with operating a vehicle while displaying an expired or improper license plate on August 13th of 2024. So apparently before you went into custody, the officers saw you driving, and they may even have that on video if you did it around the courthouse. But in any event, that is a misdemeanor. It's called an unclassified misdemeanor. It carries a fine up to $2,500. It carries a sentence of 30 days up to 6 months. Then in count 2, they're saying that you hadn't registered the car, so you were driving without a legal registration. That also is an unclassified misdemeanor as charged. another $2,500 possible fine, and another possible 30 days to 6 months in jail. Now, Mr. Johnson, I can give you a bond on this, but it looks like you want to just keep sitting there because you can't make bond if you won't.
Your Honor, it is my intent. First of all, I'm not here to frustrate or to I'm not here to frustrate or to disrupt your court or to make anything. Just simply understand. That's all I want to understand. As far as the plea, as far as the charge of misdemeanor, I'm trying to understand is that a criminal or civil offense, but I don't want to get into that today. So it is my regard to ask you, Your Honor, and request in regard to the 8th Amendment that Greenwood Court discharge or administrate a fair fine according to the historical data or registration violation in this county. That's all I ask for now. At this point, I don't want to get into whether it's criminal or whether it's whatever. But according to the 8th Amendment, I just want a fair fine, as if anybody who was driving the vehicle.
Now the defendant tries to regain control, but it backfires. The court isn't reacting to the performance, only the facts. The judge's patience gets thinner with every excuse, and the defendant's tone starts revealing more than the words do. This is the moment credibility cracks in real time.
Given I was not driving my vehicle, of course you held me in contempt. They brought me up and arrested me in contempt. So I don't know how they got me for operating a vehicle.
Well, they apparently saw you do it on your way into court.
Well, that's what I'm not. What I'm saying is it's a burden of proof on the state for that.
Right.
I'm not going to say they saw me. I don't know what they saw, but right. far as I can notice, when you held me in contempt, they went out and searched my car, which was a violation of my 4th Amendment right. They never issued me a search warrant. They never told me my vehicle was suspected in a crime investigation or any kind of criminal intent or doing anything. So my car was searched. So when they searched my car, I have multiple witnesses that saw it. When they searched my car, they pulled everything out of my car. And I guess when they didn't find it, then the violation comes. I would never issue a citation for the violation. I was just put on lockdown for the last 7 days.
Well, I think as I understand it, you were put on lockdown because you wouldn't go through booking and processing. They couldn't get you entered into their system.
No,
you refused to get your fingerprints, and you refused to get your photograph. And rather than manhandle you and wrestle you and get you to take your pictures and prints, they had to just put you somewhere safe until you would cooperate. But that wasn't what I've heard. I don't know that for a fact.
Well, if you look at the video, that is inaccurate. When I came in, I was told I was going to be.
Okay, sir. We'll talk about that just a little bit. Do you need an attorney to represent you on these charges?
I do not. I just want to, like I asked, I'm just requesting that in regards to the 8th Amendment, that Greenwood Court discharge.
That is not going to be addressed today. Today, I need to know if you want an attorney. You're waiving your right to an attorney. You don't want to hire an attorney. You don't want to apply for court appointed?
This section is the turning point. Consequences become unavoidable. The judge clearly lays out what the defendant did, why it matters, and what the court can legally do next. The defendant's reactions show they finally realize this isn't a debate, it's a ruling, about to land.
So what are the fines, Your Honor?
Well, as I said, each one of these counts carries a maximum possible fine up to $2,500.
Okay.
And each one of them carries a possible jail sentence of 30 days to 6 months, although probation is often an option.
Well, I would rather for you to just issue me a fine today. If you issue me a fine, I'll pay the fine.
Well, I cannot guarantee you what your sentence will be. That would be inappropriate to try to give you to negotiate with you and give you a fine before if you're convicted. Now, maybe if you waived your right to counsel, and you wanted to proceed today, I don't know if Ms. Gillette would tell you what her recommendations would be. I'm not bound as a judge to follow the recommendations, but again, typically I do, but I don't have to. Or you can get an attorney that can represent your rights and can help you file these motions or help you weigh your defense and decide how you want to proceed.
Well, all I'm asking, Your Honor, if you get pulled over and you get a speeding ticket.
No, we're not going to do that, sir. I just need
all I want to know is the fine. Like normally when you get a ticket or a citation, somebody give you.
I told you that. I told you that.
Okay.
So which way do you want to go on that? Do you want an attorney or not?
I do not.
Okay. Do you want to sign a written waiver of attorney?
No, I do not.
All right, but for the record, you do not want an attorney.
I do not.
And no one's making you give up your right to an attorney?
No.
And you understand that you could apply for court appointed if you cannot afford an attorney?
I do not want an attorney. I understand. Okay. I do not want an attorney.
All right. I will show on the record, both in the docket note and journal entries, that you do not want an attorney. You've given up any right to an attorney. You intend to represent yourself on these charges. Is that right?
Here comes the most suspenseful stretch final attempts. Last second, please. And a courtroom that feels like it's holding its breath. The judge stays firm, and the defendant's strategy collapses piece by piece. Every sentence here is setting up the final decision.
Possibly, yes.
And you were here last week on speeding 82 and a 65 and no insurance. Are you waiving your right to an attorney on those charges in 2024 TR 22 as well?
No, I'll answer that when I go to court on the 27th. I think you scheduled a court hearing for the 27th.
I did, and I am going to set this case today on the 27th at 9 a.m. as well. So both cases will be set September 27th, 2024 at 9 a.m. You've waived your right to attorney, at least on this case. I'd have to review the record to see if you did last week or not. But like you said, we can revisit that at your next court date. Ms. Gillette, in all of that confusion last week, did we set a bond in the other case? You can check those. If you don't have that handy, I can check the record.
Judge, he had a warrant for failure to appear for $1,000 cash surety. So he actually had.
I paid the $1,000.
Sure.
A cash of $1,000. It is a cash bond that the court is holding of $1,000.
All right. Okay. So that charge, you're free to go anytime you want to, as long as you go through the booking process. You've already, I would consider, even though the jail doesn't show you as being processed because you refuse to cooperate with the processing, which means fingerprints, pictures, signing a bond, I would consider you having satisfied your contempt. I think you've served enough time, far more than I intended for you to. It's been a week now. But you're going to have to go through the booking process. And then I don't know what the military's intention is, but I understand, is it your understanding they have a hold on you, sir?
They told me no.
Because you've got that military hold.
And I was fine with that, but I was asking about that, Your Honor. I'm not trying to drag this along, but I asked them about that. Is the military going to be allowed to come pick me up? And they told me no, I won't be able to leave until I come before you. So
I wait to take care of your charges here before you go.
Okay.
All right.
I will allow them to fingerprint me and take a photo. And if you saying I could be released.
On both cases. Well, you've served your contempt, and that's what I sent you into jail for. Now I'll give you a bond, and you're going to have to post the bond in the new case. Ms. Gillette, any recommendations on that bond? 2 counts of registration.
Judge, they're both unclassified misdemeanors. He's also got some other potential charges for the disruption in court that I am reviewing. And that's the other issue that I've got.
Okay, so there may be another issue, Mr. Johnson, but I'm going to set it at a $500 bond. You can either post cash or work with a bondsman.
I got cash. If I could put it on my card, I got cash.
All right, I don't know what the rules and procedures are, but $500 cash bond, it's 2 counts of registration. I think that's appropriate. And then if you make those 2 bonds and there aren't any other charges against you through Greenwood County, then I will see you in court on the 27th.
Well, man, how would what I don't want to happen is I go out here and post, and then all of a sudden there's another charge. Then I'm stuck here for another 7 days to see you. So I just want to give y'all what y'all need so I can get out of here and have my day in court. That's all I want.
Well, I think an attorney could help you immensely accomplish your goals, but you don't want an attorney to help you, so.
No.
All right. Well,
I just, like I said, I'm okay with doing the fingerprints, doing the photos, paying the $500 bond, and being released to the military.
Okay.
And I guess at that point, I'll see you again on the 27th.
All right. Yeah, I just don't want the military to take you away from me, though, and not let me get you back for a while. That wouldn't be any good, but that's what I told you.
They're not going to do
That's what I
that.
told you to, and that's what I'm sticking to. But now I can't tell you. If Miss Gillette has a job to do, and if she has other violations and she charges them, I can't help that. I'll have to call you back in on new charges. But that's what I'm telling you right now concerning the 2 cases I've seen you on.
Okay.
All right. Anything further, Miss Gillette?
Right now.
All right. Anything further, Mr. Johnson?
No, just want to get out of here and go handle my other affairs that I got.
Understood. All right. Thank you, sir. We're in recess.
And this is the finish. The judge delivers the outcome clean and direct, leaving no room for misunderstanding. The defendant's body language says that all this is what happens when you gamble with the court and lose. Like the video, subscribe to the channel, and we'll see you in the next video.